everybody. Hi.
DeBrouwer.
I'm really excited to introduce our last panel. Abner S. Green, Leonard F. Manning, Professor of Law at Fordham, will be moderating the platform governance panel. Thank you.
Okay, here we are. Hi, thank you, Sarah. Thanks to all of you on the Journal, and if you don't mind my singling out, Sarah's work on this has really been exceptional, so thank you for that. And I'm not just saying, I've heard it from others. So we're gonna, each of the panelists is gonna have 10 minutes, and we have a timer right here. Hi, wave hi to the timer, there you go. And Jermel, nice to see you. And at the end of the 10 minutes per panelist, we'll have a colloquy among us, and then we'll do Q&A. So I'm not gonna do introductions, you have it all in here. The first panelist is Zoe Darmain. In particular, Zoe, thank you for joining us. I know Facebook is a somewhat busy place to be these days, and we're very, very grateful you're here.
Thanks. I'm going to actually speak from the podium. So again, my name is Zoe Darmain. Really, really happy to be here and excited for this panel. I think the first thing I should set out is that I am neither a law professor nor a lawyer. I have watched every episode of Ally McBeal, but that's pretty much my only legal qualification, so please bear with me. I'm here to talk about the Oversight Board. We heard Kate talk about it a little bit today, but I'll go in depth and here to take any questions on that because I know it's sort of a very interesting and timely topic. So briefly, what I'll explain, how many of you have heard about the Oversight Board? Okay. How many of you have heard it called the Supreme Court? Great, about the same percentage. So maybe what I'll do is level set about what it is and what it's not. The board specifically will be a body of independent experts who are charged and mandated with giving us their independent oversight and judgment on our content decisions. So as Kate mentioned, it will really have two functions. So the first function is to uphold or reverse decisions on difficult or contested pieces of content. And that decision, if they overrule us and say this piece of content that you left up has to come down, that decision will be binding, even if I disagree with it, even if Mark Zuckerberg disagrees with it, we will be obliged to follow the board's decision making. The second thing that we'll do is that it will give us advice on our policies. So in reviewing those cases, if the board finds that our policies need some sort of adjustment, the board can give us a recommendation to say, hey, Facebook, I think you're not clear in what you mean by newsworthy or who qualifies as a politician or any types of those really fundamental questions. Those will be advisory recommendations. We will have to take those back through our policy setting processes and then report back publicly to the board and to everyone, essentially, on how we've taken action on that recommendation. What I should clarify is what the board won't do. So obviously, the board of 40 people or 400 people or 4,000 people would not be able to decide on every single case that comes before us. We make millions of content decisions every week. Facebook will continue to make millions of content decisions every week. The board will be able to hear a limited number of cases, and so that's why we're really looking at highly emblematic cases and why the policy function is so important. What are cases that are so difficult to adjudicate that it will be very valuable for the board to render its judgment and tell us what it highlights about our policies that might need changing. It also won't address issues beyond content. I will say ads are content, so ads will be in scope. But things like AI or data privacy, those things are not in scope. We just had to draw the line somewhere so that the board could actually do its work. And content is such a huge and difficult area of work already that the board will have plenty to do. So it will be approximately 11 to 40 members. We know that the board won't be able to be perfectly representative. We have 2.7 billion people on our platforms. However, we know that it will be critical for the board to be balanced in terms of geography and gender, disciplines and expertise. As Kate mentioned, there will be around 2 or 3 co-chairs who will lead our work in things like case selection, other board member selection, and the governance of of the board itself. Cases will be heard in panels of 5, and decisions will be circulated to the entire board and reviewed en banc. Sorry to use all of the legal analogies, but I thought it would be appropriate for this crowd. And as we mentioned before, there will be public decisions both by the board and public responses by Facebook. We didn't develop this in a vacuum. We actually talked to well over 2,000 people, both in person and through an online public consultation. We wanted to make this as wide-ranging and open a consultative process as possible, and we have changed the way that we're doing business based on the feedback that we received. So for example, and this is just one of many, many design decisions that we made as a result of feedback, we were originally just going to select the first 40 members of the board, and then after that, have the board select itself. We heard that that would not set the board up for success in terms of legitimacy and credibility. That's why we're selecting a few co-chairs who will then select up to 15 or 20 members to start together with us. And then over time, we will, the board itself will take the lead on membership selection. Again, only one example. I could go into many where we've changed the way that we are thinking about the board based on this feedback process. I love a slide that has really tiny boxes and small print. So that's why we have this one for you. It's also available online in our latest newsroom post on the board. The reason that I'm showing you this is essentially just to give you an idea of how the process will work. So Facebook and users will be able to refer cases, but then the center of gravity is really going to shift to the board. We think it's critical that the board exercises its independent judgment. We don't think the board would be credible if it weren't allowed to do that. And so you actually see in this chart that, that Facebook and users, we're over here on the right, but really when the board's deciding on cases, the process is going to shift to the left of this screen. And then we come back only when we need to provide information to the board that it reasonably needs in order to decide on cases. So the structure that we have set up, this is a complicated slide, but the main thing that you need to know is that there will be an independent trust, and that independent trust will house the board. And so we will be funding the independent trust, and so there will be financial independence from Facebook. We'll be looking at providing multi-year funding. The other key thing to know about the trust is that it will have the removal powers for the board, not Facebook. People said that it was very important that for the board to be independent, that Facebook wouldn't be the one actually removing board members. We're thinking that removal would be in cases where members have violated their code of conduct. That code of conduct will also be public. Roughly where we are, we released a charter last month in September. That gives a lot more detail on the mandate and functions of the board. Now that we've kind of released that foundational set of documents, what we're going to be doing in October and November is really working on the board's operation. This word is so hard for me to say. Operationalization, and also its procedures, its rules of procedures, which will be codified in a set of bylaws. Those will be made public. And then in December, we'll be moving towards announcing the first set of members. The board itself will convene for the first time and begin to hear cases early next year. So I've thrown a lot of information at you. I am glad to talk about this with my co-panelists and happy to take your questions. So with that, I'll pass it back to you, Abner.
We'll have questions at the end. Thank you, Zoe. I'm sure all of us have lots of questions. But to make this not just be a let's find out what Facebook is doing panel, we'll move on to Robert DeBrouwer.
Thank you. Good afternoon. I'm Robert DeBrouwer, the co-chair of the Digital Media Practice Group at the law firm Pryor Cashman. I have a question. How many people in this room were not yet born in 1990? The reason I ask that question is because I think it's important when making these considerations to understand context and the history and the evolution of the law. I began practicing digital media law in 1990. Before there was Facebook, before there was Google, before there was ICANN, before there was Netscape. I had a Prodigy account and a CompuServe account. SWTH23A was my Prodigy handle. Anyway, I mention that because I think it's very, very important to think about the normative principles where we're at today and to try to understand why we got there and how we got there. Many people will say that as a matter of law, for example, the First Amendment doesn't govern social media platforms because they are private citizens and not the government, which is in fact true. But at the same time, if you look at the operational principles of these platforms, like YouTube, for example, it is very much not only driven by, but dictated by the Digital Millennium Copyright Act. And so there's a whole notice and takedown regime. There's a whole content ID policy, which you may understand, and I don't have enough time to get into the weeds of all of this. But that very much has dictated why they operate the way they do. And then going back again to the early 90s, there was a case called Stratton Oakmont versus Prodigy, which was the precursor to the Communications Decency Act, Section 230C, which is the only part of the act that has survived First Amendment scrutiny, because the other portions of the act were content-driven speech regulation. And so if you look at those two laws, there's a reason why there's this sort of laissez-faire kind of hands-off approach, for example, to copyright, when you look at user-generated content in YouTube, and why there's this sort of proliferation of millions of messages every single day, because Congress decided that in order to foster the development of new technologies and the internet, that we would shift the burden to copyright owners to have to notify when particular content that's alleged to be infringing exists on a platform. So you're in a regime where no liability, safe harbor, we want to maintain our safe harbor, we're not going to be hands-on. The same thing with respect to the Communications Decency Act. In order to have immunity, you cannot be the publisher or speaker. So going back to the mid-90s, before 1996, when I was doing a lot of work in magazine publishing law, and I was doing pre-publication review of magazine articles before they got published, even if it was a letter by a third party, the publisher would be liable, as is the case today, in most instances, potentially for defamation. And we were talking earlier about defamation and territorial bounds, and that's very, very important, because in the United States, you know, we have the New York Times versus Sullivan, which for public figures and newsworthy public interest events, there's a particular heightened standard for liability because we cherish First Amendment principles here in the United States. So there's a very, very significantly higher threshold for liability than perhaps in Austria. And so what may be fundamentally wrong in Austria, and you can geogate that content there, is clearly acceptable here. And that's why when we were talking about that earlier, it's so shocking, because you will have this sort of extraterritorial effect. But the point I'm trying to make is that you have to go back and look at context. You know, why did these rules develop? What was happening at the time? So in the Stratton Oakmont versus Prodigy case, it was Stratton Oakmont, which is actually the firm behind The Wolf of Wall Street, if you've seen the movie, that, you know, they were alleged that on a bulletin board on Prodigy, they were being disparaged and defamed. If you look at an earlier case, Cubby v. CompuServe, that kind of went the other way. In that case, it said that CompuServe was not a publisher. They were more like a distributor, and I don't want to get into distributor versus publisher liability. That will take up much of my 10 minutes right there. But distributors typically are not held to be liable because they don't, from going back to common law principles of liability in terms of publishing, They don't have the ability, if you are a sort of magazine newsstand, to read every single article and magazine that comes in. But if you're a particular magazine that is on display there and you have a limited amount of information that you're publishing, as a publisher, you can vet your content and make sure that it is not defamatory, et cetera. And so there was publisher liability, no liability for distributors. And it was in that context when in Cubby v. CompuServe, the court said, well, CompuServe is kind of almost like a common carrier, like the phone company. They just allow lots of people to have conversations on there. They're not involved in the publication itself, no liability. What happened, because this was the very, very early days of, I won't even say internet, even though Al Gore had already invented it, it was really online publishing. And so Prodigy said, we want to appeal to families. There was a lot of really horrible, nasty stuff going on online those days. You could use your 2400 baud rate modem to dial in and find all kinds of child pornography and really hellacious stuff that is much more regulated these days. And so Prodigy said, we don't want to be part of this wild, wild west. We want to position ourselves to be a family-friendly environment. We're going to have moderators that are involved in looking at content and removing things that we thought was disturbing. So through their governance model and platform, they created liability because the court in New York said, well, you're different, and therefore you're liable. And so I think you have to look at the context of your governance model to make sure that you're going to be in an environment where you can, uphold your duty to your shareholders, for example. The board in a public company like Facebook has a duty to its shareholders. Now, the absolute duty under corporate law isn't that you have to necessarily be profit-driven, but it has to be in the best interest of the company. So certainly, removing yourself from potential liability is a significant driver. So I think we have to be very, very cognizant of the history, the fundamental principles that, governed how we got to this funnel in the first place. That's where we are. And to ensure that you're not creating a landmine of potential exposure and liability and risk. And as a practitioner on the front lines, I don't typically take sort of positions, although I'm at a point in my career where I don't have to take cases if I disagree with them fundamentally. But, I get a call, I'm going to try to make this person anonymous, from the CEO of a public institution in New York that says, I admittedly was having an affair on my spouse with someone else from my organization who was having an affair with their spouse, and someone with a drone captured it in a parking lot, and now they've posted it on Facebook and YouTube, and they're harassing me. This person called my significant other and told them about this footage. I have to deal with that. How do I help this client? So I have to look to the sort of governance policies of the respective platforms, and I have to say, in New York, you don't really have any privacy law except for misappropriation and maybe criminal trespass. And so you have to wend through, how am I going to help my client? How am I going to get to this point? And because it wasn't an intellectual property violation, it was sort of mere harassment, there weren't necessarily available means to enforce, a potential injunction to get this person to stop harassing my client. Anyway, my 10 minutes is up, and there you have it.
Thank you so much. All sorts of thoughts about that. We'll wait. Next up is Evelyn. Is it Dueck?
Yes, thank you.
Evelyn Dueck.
Great, so that's my name. I'm a doctoral student at Harvard Law School studying platform governance, so this is a very exciting panel for me to be on. Going from the sort of very frontline practitioner aspect, I'm going to take us right up to the macro 1,000-foot view and sort of ask, why are we here? And not in an existential sense, but why is there a thing called platform governance that we are having panels about today? Why is this suddenly something that's really, really interesting to a lot of people? And I think that we're, at this really potentially pivotal moment in the history of platform governance and in the history of online speech. Content moderation systems generally, so the way that these private platforms decide what speech is and isn't allowed on their services, has been going through a crisis of legitimacy. That's at least since 2016, although people like Dr. Klonick have been studying it for well before then. But since at least 2016, there's been this real public reckoning around these hugely publicly consequential decisions that these private companies are making about the scope of public discourse. So when Facebook and YouTube decide to take or leave up, I always get that wrong, a slowed down video of Nancy Pelosi that makes her look drunk, that shapes public debate and potentially has electoral consequences. When these companies define hate speech as one thing, but decide that politicians don't have to comply with those rules, that's a fundamental judgment about the scope of public discourse and public debate. And that's really important and has systemic real-world effects. And they make all of these decisions without complying with any of the usual rule of law values that we think of as that should attend decisions about public rights and speech rights. So we don't necessarily always know what all the rules are. So there's a severe lack of transparency. Who is a politician under Facebook's rules? Well, Zoe can tell us today, maybe. But in general, we don't necessarily know that. We don't have a great mechanism in all cases for challenging these decisions, and there's a severe lack of due process. Even the platforms that do provide you with a way of appealing, there's no full Supreme Court argument about the context of the speech and things that you might think of as attending something that's a really public and important fundamental right about speech. And then you might say, well, so what? As Robert was just mentioning, these are private companies. We don't normally think of rule of law as something that should apply to a private company. Evelyn, why are you talking about the rule of law? That's ridiculous. And in the US, that's of course encapsulated in the state action doctrine. The First Amendment does not apply to private companies. But in general, legal systems have different rules for holding private companies to account than they do public actors. So we're in this interesting moment where we have these private companies making these massively systemically important decisions without proper rule of law or proper accountability. And I think we find ourselves in this moment of what I've been calling laboratories of online governance. So that's obviously drawing on Justice Brandeis's famous analogy of the states as laboratories of democracy. We've got these different platforms now trying different things and seeing what works best. So most of them have been feeling a lot of public pressure to do better, to open up, to have some sort of more transparency and accountability, and so they're publishing their rules a lot more than they used to. But there really are still platforms that only pay lip service to the idea that they should be really public regarding in the way that they make content moderation decisions. A lot of them are still very much shareholder, revenue, advertiser driven. On its face at least, Facebook's Oversight Board project seems like a bet at the opposite end of the spectrum. Now, let's be clear though, it's not pure public-mindedness. I mean, I don't know that Zoe would necessarily disagree with that, but I don't think it's purely from this idea of, the greater public good. I think it's fundamentally a bet from the company that the legitimacy of its decisions matters for its own interests. And it matters more than getting its way in every single individual instance. So while other platforms might be doubling down on their short-term interests and the fact that maybe they don't need to necessarily publicly explain why they make the decisions that they make every single time, Facebook appears to be making a different wager in this moment. That accountability and legitimacy can reassure users and, importantly, can reassure regulators, perhaps, of the value of its product. And so legitimacy, Facebook hopes, in this body will become part of its value proposition as a product. Will it work? Maybe. Kate gave us a great image earlier of I can't quite remember, a box on the top of a hill going down, tumbling to its death or something. But we will have to see whether it will be something, whether it will be successful or not. But in that evaluation, we need to be clear about what it can and can't do. And I think we've seen some of that today. So importantly, it is not going to settle intractable, highly charged disputes about the proper limits of free speech. We are always going to have different ideas about what is defamatory, what is hate speech. This body will not be able to create global norms where none can exist, and where countries make different legal rules. This body is not going to be able to, suddenly bring us all in a kumbaya moment of the limits of acceptable discourse. And it also won't be able to provide due process in any but the smallest fraction of the decisions that Facebook makes about speech every day. It's going to hear potentially a couple of dozen cases every year. Facebook makes millions of decisions about speech every day. So what can it do then? First, it can provide an independent check on Facebook and some sort of separation of powers, a diffusion of the enormous power that Facebook currently has to decide what is acceptable in public discourse, and what Mark Zuckerberg currently has, the power to decide what you and I can hear when we go on what is a very significant part of the internet for a lot of people. So it's going to diffuse that, provide an independent check, and people who are hopefully going to be having regard to other values other than just Facebook's own interests. But also, and I think this is really important, it can provide more sort of a space for public reasoning and transparency and contestation around those rules. And so in doing so, in allowing a space where the reason why rules have been formulated the way that they have been can be explained, there is potentially more room for people who, even though it's those that disagree with those rules, come to accept them as somewhat more legitimate than just currently they sort of descend from this blue box at Menlo Park and we're just like told to accept them. So that's the moment we find ourselves in. I am cautiously optimistic, if only because I think it is possibly the worst option except for all of the rest. It's the first genuine attempt that I've seen to cut what I see as the Gordian knot of content moderation that we have at this moment, which is that on the one hand, having private companies decide such monumentally important decisions in an unaccountable manner is deeply problematic, but governments doing it is potentially much, much worse. Even if they could do it practically at the scale at which these decisions need to be made, which I think there's a severe question about whether that would even be feasible. Them deciding it on such a micro level, what's the acceptable realms of political discourse, I think would be at odds with what most of us think of as, the rationales behind free speech. So we have this problem, so who's going to do it? And so this is a bet and an attempt to try and solve that intractable problem. And I'll leave it there.
Thank you, Evelyn. Okay, I'm sure like after each speaker, all of us wants to immediately ask them questions, but we can't do it that way. So next up is Nadine, and then we'll have a little colloquy here. Nadine Strassen.
I defend your right to ask questions first, of course.
No. Nadine Strassen, the famous Nadine here. We're very glad you're here with us, Nadine.
Well,
I've known Nadine for
it's becoming
a
an
long time.
annual tradition. I'm really honored to be here with people whose writings and works I've admired for so long, including Kate. I only got here in time to hear Kate because I was speaking on another panel about somewhat different issues this morning. And I have to tell you, I totally agree with Evelyn's assessment. I have often said, for me as a civil libertarian, I instinctively distrust government, am skeptical of government. But it's a question of whom do you distrust more? Government is at least in theory accountable to we the people, to quote the opening words in the Constitution, whereas the private sector has a legal responsibility, as Rob explained, to the company has to be responsible to its shareholders, which I gather in the case of Facebook comes down to one person. And it's a structural issue, right? No matter how much we might trust that one person. I still am holding out for what my civil libertarian ideal is, which is that it should be up to each individual. We should have freedom of choice as to what kind of speech we do see and do not see and are not forcibly exposed to, what kind of community we want to participate in online. That was the ideal of the internet when it first came to public consciousness. And I'm going to go take an even deeper dive into history than Rob. I think I can take full age rank on you. When the internet first hit the public and political and media radar screen, of course, it had been known to scientists before that, the immediate reaction completely across the political and public spectrum was, this is dangerous, we've got to do something to curb it. And so the Communications Decency Act was rammed through Congress with almost nobody voting against it on either side of the aisle. And Time magazine had a cover story that was just, depicting the horrors of computers, showing at that time the main social concern was about child exploitation. There was a lot of horrible evidence about child abuse that was going on. So you take the new communications medium and you combine it with whatever the major social issue is of the day. And of course, we've got to censor that medium to protect against that evil. And so when the ACLU entered into the picture, we created a cyber liberties task force to examine whether there should be the same tried and true civil liberties principles that we have been defending now for almost exactly 100 years in this brave new world, or should the standards be changed, as was being widely argued. After a lot of examination, we decided that the same tried and true principles should apply. That was an extremely unpopular position. We were accused of supporting child pornography and child exploitation because that's what everybody thought would happen with the internet. And even the inventor of the internet, Al Gore, and the Clinton administration was on the other side, arguing that the entire internet should be subject to the same very strong constraints on free speech to which broadcast television is still relegated. To our surprise, though, the United States Supreme Court came out essentially 9-0 with a couple little detailed disagreements by a couple of the justices, but basically that the same free speech principles should apply, number one, as applied in the highly protected print media. And the second really important point, and I'm mentioning these because I think they both carry through to social media. The second point was that it should be at determinations about what we see in our own homes and what we decide our own children should see or not see should be made by individual end users, not at the provider end, but at the receiver end. And those seem to me to be the same principles that we should strive for in all new media, including the social media. And that's what I and other cyber libertarians, if I can quote some organizations that have been working on this issue, not only the ACLU, but afterwards along came wonderful groups that are specializing on these issues. The Electronic Frontier Foundation, the Center for Democracy and Technology, Article 19 was already mentioned, Access Now, and all of these organizations are advocating that technological tools should be provided for individual end users to make our own choices. We should be able to have different filtering options. We should have access to communities that are more or less regulated. It shouldn't just be a one-size-fits-all solution. And that wealth of choices can be provided in two ways. One would be by having, a very, very large number of social media platforms from which we could choose, that they would be designed along the spectrum of free speech and lack of free speech, different community standards on each one. A freedom of choice for individuals could also be facilitated through having even the dominant giants such as Facebook provide to their users the options of different kinds of filtering. And Zoe and her colleagues have been so nice as to continually consult me and try to pick my brain and not to subject to any non-disclosure agreement. And the last two folks that I spoke to in your shop said, yes, we are working on these technological user empowerment options. They're not immediately going to be available, but hopefully that might be something that's in the works. The other analogous conclusion that we had advocated with respect to the internet in general, that the Supreme Court upheld, that I think also applies to social media, and that is the same First Amendment standards should apply, which is not to say that government should force the social media companies to comply with First Amendment protections. I would oppose that as violating their free speech rights, but that the platforms, the giant platforms, I think the smaller ones should have autonomy, but those that have so much power over the public square that they, in effect, have substituted for the role of government, I think they should voluntarily comply with, I'm not going to say First Amendment standards, I'll say international human rights standards. And as that question acknowledged, that was the position that was advocated by David Kaye, who's the UN Special Rapporteur on freedom of expression. It's been advocated by Article 19, the International Free Speech Organization that takes its name from Article 19 of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights. And it's interesting, Zoe, when I was having this conversation a week or two ago with your colleagues, I kept pushing for international human rights standards because Facebook and some of the other giants have said that they agreed with the spirit of that recommendation, maybe not necessarily the details yet. And your colleagues pushed me and said, well, don't you want to push for the First Amendment rather than international human rights? And I have two answers. Number one, and Evelyn reminded me just before we started this panel, it is just not nearly well enough known as it should be that the international human rights standards of free speech under Article 19 of the ICCPR, less of a mouthful than the International Covenant on Civil and Political Rights, have been authoritatively interpreted by the body that is designated to do that, namely the UN Human Rights Committee. The authoritative interpretation is incredibly close to core U.S. free speech principles. And since I only have a minute left, all of you students who have taken constitutional law, Brandenburg versus Ohio, the kind of emergency test, an imminent danger, a specific danger, that has been embodied in the international standards together with what I think is also a core principle here, and that is narrow tailoring and cannot be undue vagueness. Some of you may know that Article 20 of the ICCPR seems to be deeply inconsistent with U.S. law because it requires countries that are signatories, many such as the U.S. have made reservations to this provision, but it does require countries to affirmatively outlaw hate speech. But what is not well known is that that article has been authoritatively interpreted as requiring that any exception has to comply with all of the other requirements for exceptions under Article 19, namely satisfying that demanding emergency test and not being unduly vague. So I would urge these companies, consistent with the United Nations recommendation that businesses, major businesses, voluntarily adhere to international human rights standards, that they do that with respect to free speech standards.
Thank you. I have some things I want to ask, but Zoe has a point of personal privilege first.
Thank you. Nadine, I really appreciate you myth-busting around the difference between the First Amendment and international human rights standards, because this is a misconception that I hear all the time. Oh, the First Amendment is so much stronger than the protections in the international human rights law, norms, and standards. I myself come from a strong multilateral background. I came directly from the UN to Facebook. You carry around the Declaration of Independence. That's maybe
Yes,
one of-
yes.
I carry around the UN Charter. And so I would say, the last thing that I would say on this is the people who are afraid of the word international or international human rights standards, they forget that the person who wrote the UDHR was Eleanor Roosevelt. So it's hard to deny that there is a tradition and a red thread that links from our traditions and the international regime. Thanks.
Thank you. These are all fabulous, and I have all sorts of questions, but I just want to make one sort of law professory First Amendment thought. I actually carry around a copy of the U.S. Constitution, so we're all carrying different, and my ACLU card wherever I go. I do, Nadine, especially after the 1988 debacle in that election. So I just want to make a little bit of a pitch for the public-private line formalism that we have in the U.S. That one of the reasons we have such strict requirements about government regulation of speech in this country is because of a distrust of government, because the government has a monopoly on legitimate coercive power, but that when it comes to private actors who are not the government, we might think differently. Now, I know that private actors can become very powerful, and I think of my fabulous colleague Zephyr Teachout, who has been pushing all sorts of norms about anti-concentration of power for so long. But that aside, it seems to me that private actors have a great opportunity to define what kinds of speech cause harm in a way that maybe we don't want the government to do. And so my instinct is that if I were running Facebook and I had certain views about what speech is harmful and what isn't, I might just allow the speech up that I think is not harmful and take down the speech that is harmful. It's my company. And so part of me feels a little bit like, why does Facebook think it needs to have the whole thing, which is so elaborate and fascinating? Why can't Facebook just say, we have certain values that we care about, we're going to promote those on our platform. For the most part, they're going to jibe with open discourse, but there are certain things that we're a private company, we don't like. We weren't the government, we couldn't regulate it, but we want to have them taken down. So that's my one sort of thought, and I pose that as a general question, but I really want to let all panelists talk about that or whatever else they've just heard that they want to talk about. So why don't we start? Zoe will get to speak again, but she'll go last. Robert, you go next.
I think one of the reasons it's fundamentally important now is because there are those who claim that misinformation and bad speech on Facebook had a very significant impact on our last election. And so I think that it's a very important public issue, and leaving it to the board of directors or Mark Zuckerberg or someone, it doesn't take into account the sort of, public harm that could be caused. And so I think they want to be seen as a better public citizen. And as you were saying, Evelyn, I think that it's not merely the sort of altruistic kind of thing. It's messaging in a way that I think helps provide legitimacy to the platform that will benefit the shareholders.
Yeah, I mean, this is whenever I'm talking about the Facebook Oversight Board with American lawyers, this is the response that I get because of the very sort of negative rights conception of liberty. Like freedom is stay out of my business, and that includes private actors. And I think that it's just really been in the past few years where there's just been this massive public turn of public opinion where that just doesn't seem to be good enough anymore. I think it's also partly that other legal systems have a much more, we call it horizontal application of rights than you do in America, where they do have a greater expectation of private actors to not infringe on the rights of others, which comes from a more sort of social democratic norms and ideas. And as these companies become more and more global, they find themselves subject to these kinds of pressures in more and more of their markets as well, I think. So that informs that response. But I think you're right, and I think that there's other platforms that have a very similar response to you and say, no, we're not going to.
Just
to
note
like-
that I want to just clarify my point. My point isn't that Facebook shouldn't account for the harms that happen via Facebook. I think Facebook should pay a lot of attention to the harm. I'm not a libertarian on this. I just think that I don't know why Facebook needs to set up a board to sort of start looking like it's a governmental body, that it needs independence and legitimacy, and not just say, we're a privately owned company, we're happy to hear all of your input on what counts as harm, and then we're going to tell you, we're going to put up a platform that has certain speech and doesn't have certain speech, and it'll be the Facebook determination of harm versus no harm. I did want to ask Nadine a question, and here I want to channel, I just recently read Marianne Frank's book, The Cult of the Constitution. I'm not sure if Nadine's read it or not, but
Debated her.
okay, so if Marianne were here on this issue, I think she's concerned that the ACLU is too free speech absolutist, and that in fact with her colleague Danielle Citron, who recently was recipient of the MacArthur Genius Award, a Fordham Law alum, we're very proud of her. They have advocated that there are certain kinds of distinctive harms that are caused by the internet that should be the subject of more government regulation. And I wonder if you wanted to say anything about that or anything else that you've heard.
There's so much. It's all so complicated, and I respect Marianne a lot, and I just suggested that she and I have a discussion together about our respective books. Well, first of all, there is a lot of expression that contains hateful messages and disinformation and defamatory messages that I think can and should be punished, and that's a perspective that is not as well known as it should be too, right? We so often hear generalizations, hate speech is not free speech, but then the opposite generalization, oh, government can't punish hate speech. Well, yes, government can if it satisfies that general emergency test, and there are many kinds of hateful speech that do satisfy it. This morning, I was on a panel with a lawyer from the Lawyers Committee for Human Rights Under Law, which had successfully brought a lawsuit against social media trolling, and I can't remember who the defendant was, sorry for all you litigators out there, but the substantive point that was so interesting, this was on behalf of an African-American woman, Taylor Dumpson, who was with us this morning, who was the first African-American female student body president at American University, and she was not only subject to an incident of hateful expression that I cited in my book as being punishable as a true threat and a so-called hate crime, but in the wake of that, she was subject to this organized troll storm, and I believe it was the online publisher, the Daily Stormer, that drummed up the troll storm of harassment against her, targeted harassment that caused demonstrable emotional suffering and intimidation. She didn't even want to leave her dormitory room, and I'm told that it did result in a judgment against the speakers, the online harassers, and I'm told that was the first time that judgment had been reached. It was under the human rights law in the District of Columbia. There's a similar lawsuit that's, last I know, pending, not yet done, in federal court in Montana, where a woman was subject to a troll storm that was organized by somebody associated with Richard Spencer, very anti-Semitic, but very targeted. And again, I'm not sure to what extent Danielle and Marianne want to go beyond that, but sad but true. There's a lot of expression that's already illegal and should be subject to punishment online.
So I'm going to give Zoe another shot at all of this, and then we'll open the floor for questions.
Thanks so much. I would say in response to your comment, Abner, why doesn't Facebook and all the other big tech companies just draw the line in the sand, make the rules, and then we're private companies, and so that's just what we have to live by? I would say to that, that's sort of what we're doing already, and I am not 100% sure that that's being very well received. So that's why we are creating this laboratory of experimentation, as Evelyn said, because we think that what's wanted from us is a different way and more external voices in the process. And so some people have cynically called this just outsourcing really tough decisions. I would say that it is bringing to light the really difficult conversations that are involved when there are trade-offs that have to be made in balancing different rights. So where Facebook has drawn a line in the sand is a few weeks ago we updated our community standards and the values that sit atop them. We have made a very clear value judgment to say that free expression is paramount. That is where I think it is appropriate for us to draw a line in the sand. We say free expression is paramount. Here are the other values that we'll be balancing when we make these tough content decisions. So, but as far as individual balancing for individual cases, I think there is value to have other people say, should we really value safety here over expression in this case? Should we really value expression over human dignity in this other one? Seems to me that that's not something that you want a bunch of people in Menlo Park in a conference room to be deciding on our own.
And interestingly, I'm actually more sympathetic to what I would call the many voices can reach a better judgment argument than I am to the, by making it independent, we're going to gain legitimacy argument. They're related, but they're not exactly the same argument. I think let's open the floor for questions. We have a lot of people in this room and a lot of, so do you have a process for doing this? Are there mics or how do you want to do it? Okay, so we'll start with this gentleman in the front row and then I'll look over this way. Yeah.
Hi, question for Professor Strawson. The idea that we might be able to each individually choose sort of what kind of content we see on a given platform strikes me as really intriguing, but as I try to play out how it would work, I feel like it starts to fall apart, at least the way I would think it through. So suppose I give you a set of sliders, 1 to 10, you tell me how much nudity and graphic sexual content you're willing to see, and then how much violence, maybe all the way up to ISIS beheadings, at 10, or you tell me how much profanity you're comfortable with, and on down the list, right? You could create such a thing, I can imagine that, but we hear a lot of criticism that platforms are encouraging conspiracy theories and people to believe that those who are victims of school shootings are actually crisis actors, and there's a range of content out there that the public is increasingly saying is harmful, even if you want to view it, right? And so I feel like you have that problem. And then also I feel like even with a lot of fine-grained controls, you're still gonna be asking the platform to make a lot of decisions for you. And it feels like now, I don't know, I'm in this weird individualized version of the platform where I don't know what they're hiding from me, right? Like, even though I chose the options, right, it feels really weird that I can't know, like, what all actually was said in response to that video or, or so on, right?
So thank you for giving me an opportunity on the first point that you made. If I had had more time, I would have made that initially because I was addressing one of the reasons that's given for content moderation, and that is to protect the user himself or herself from seeing things that they don't want to. But you're absolutely right that another concern here is, well, what impact is it having on other people? And I suspect that's even forefront on most people's minds. They tend to, well, now self-censor there, but so there I would urge exactly the same response that I urged to hate speech, terrorist content, disinformation. Choose whatever speech that you think could potentially do harm. First of all, a lot of it is already subject to punishment, but I do agree that a lot of speech that is at least potentially harmful is constitutionally protected. That doesn't mean we do nothing. The fact that I oppose government censorship or censorship by Facebook doesn't mean that we roll over and play dead. The question is, what do we do? And one of the most aggressive things we have to do, no matter what, is vigorous media literacy. starting at the earliest ages. People simply have to be trained to somehow sort the true from the false, to be skeptical, to learn how to do fact-checking, and a tremendous amount of resources are going into these efforts through foundations, through educational institutions. A lot of experimentation is going on with a lot of funding from the social media companies themselves, which is wonderful, about counter speech online. Yes, it's true that it's easier for hate mongers to have platforms and to speak to each other, but it's also easier for other people to engage with them and interact with them. And I've just written a chapter that deals with some of the not only counter speech initiatives that would include rooting people who are showing signs of interest or being recruited by terrorist organizations, rooting them to, or Holocaust denial, to root them to other sources that would counter that information. It includes direct engagement with people who are already hate mongers. It includes providing support for people who are subject to disparagement. And what's interesting about the social media is not only does it make it technologically more feasible to use these more speech alternatives to speech that we dislike or fear, but it's also easier to study the impact and the effectiveness, and it's all very preliminary, but there's this whole new field of what makes for effective different kinds of counter speech.
Okay, gentleman back there.
Sure. Thanks, everyone, for being here and taking the time, obviously. I had a question, Zoe, based both on this panel and on a question you answered on the earlier panel, specifically talking about politics. And I used to work in local politics, and we bought a lot of Facebook ads, so it's particularly interesting to me. But you talked about how determinations would be made regarding whether or not something was a direct quote or whether that was, making a false assertion, and then that would be assessed by some independent third party. Does that fall under the purview of the board specifically that you mentioned earlier? I didn't really quite get the political decisions on that presentation. And does the board then make the decision kind of determining who is and isn't a politician? And then perhaps the rest of the panel could comment on whether or not they think that's an effective way of doing that.
Thanks for that question. I should clarify, our discussion, I think, earlier in response to Kate's was specifically around a policy decision that we made and released and that Nick Clegg talked about. I think it was last week or maybe the week before. That policy is live now, and the board is not yet in existence. So now I'm going to move into the kind of theoretical, forward-thinking kind of experiment. So I could foresee a case where there is we would have a very difficult time determining whether that would be something that we would consider important political speech that has a newsworthiness value, or whether that is hate speech that should be taken down from our platform. I could foresee a case in which a piece of content draws a very fine line between hate speech of the kind that a politician would say, or satire of that hate speech. Those are really difficult things to determine, and in those cases, I could see that coming to the board, and the board saying, yes, we would like to make a determination of whether this crosses the line or not. In that case, we would have to take the board's decision. So, for example, if the board said, you got this wrong, you thought this was hate speech, but actually this is important political speech, it's satire, etc., then we would have to abide by their decision and restore that piece of content to the platform. I hope that answers your question. If you want more clarification later, we can certainly talk offline.
So it could work the other way around too, right? That the board could ask you to take something off that you thought.
Correct.
Okay.
That's correct.
Yes, Roger. You want to get the mic?
Thank you very much to all of the speakers, and I suppose this question is for all of you, but Zoe Darmaid, perhaps you could respond. we've heard that the United States has a culture that is more distrustful of the government than some other cultures. And I think that that's probably right, which is why we have the formalism about public actor and private actor. And against that background, I was wondering why it is that, given this dissatisfaction with the way that Facebook is currently in a private actor mode, responding to the kind of issues we'd be concerned about, why it is that the customer base would want it to start looking more like a government with this very elaborate system.
That's a great question. So I hear a lot, or I hear very often, why are you setting up a court? Why are you stepping into the function of a government? This is the purview of governments. First of all, the Supreme Court is a terrible, terrible moniker, and there is no perfect analogy to this board. It's certainly not exactly like a court. There is this aspect of giving advice on our policies, which I don't really see kind of an appeals court doing. And so to me, it's understandable why people would lean in on a governmental metaphor, but clearly this is nothing like a government structure. No government structure's ever been set up at the pace that we're setting up this board, for example. And secondly, I would say that this does not in any way replace the need for government action. So we as a company have said that we welcome regulation by governments, and the board is really looking at cases that would, in very few legal regimes, would be considered unlawful, if any. So the cases that the board will hear are difficult and disputed specifically because laws don't cover them, and so we see it as complementary to the work that governments can do. There is also just the question of the fact that governments work at a much, I'm not going to say slower, but different pace than the private sector. And we feel like so many of these decisions are consequential and urgent that we can't really afford to wait.
I can comment on that, having headed the ACLU for almost 20 years, that Americans, it's a generalization, but it has a lot of truth to it. People distrust the government, except when they feel really strongly about a particular problem, then they want the government, including on censorship. My friend, journalist Nat Hentoff, wrote a book a couple of decades ago whose title said it all: Freedom of Speech for Me, but not for thee. And the subtitle was How the Left and Right in America Relentlessly Censor Each Other. I've testified in Congress quite a few times on these issues, and it amuses me. You can either laugh or cry. I choose to laugh. That every single member of Congress who has asked questions, I'm usually testifying with Facebook, Twitter, and Google, they are all beating up on the social media companies and the search engine company for expression that is so dangerous. Why aren't you taking it down? But at the other side of their mouth, every single one of them gives an example of speech that is not being sufficiently protected. And that's why I think, no two people can agree, but all of them are using these companies as an ink blot to impose whatever their values as to what should be more protected and what should be less protected. And by the way, that's why I think, and I've made this pitch before, that the business interests of the companies, to me, would also coincide with that end user empowerment, because you're never going to satisfy anybody, let alone everybody.
I'll just add that from teaching the First Amendment course and hearing really both sides of the argument, the sort of well-drawn distrust of government side, and then the sort of why do we consider this a harm and not that a harm? After we talk about Brandenburg and Chaplinsky and cases like that, then we get to the Skokie case in Illinois, and it's like, well, why don't we have another category of speech where the Skokie is the landmark case? We don't have that, and why is that? And just so I guess for a lot of us, the question is the internet different in kind rather than in degree? Are there harms now because of the virality of the internet and the ability to both spread different kinds of harms from hate speech to incitement to falsehoods. Do we need to have a rethinking not just of how companies like Facebook should self-regulate, but about how our First Amendment doctrine should work? I mean, I think that's a question that maybe the push will always be against it, but I'm not persuaded. Every year I have students in class who push very eloquently for a more restrictive set of First Amendment rules because of the internet. Any on this or on Roger's question, or should we take another?
I'd love to say something about that because Justice Kennedy wrote so eloquently in the Packingham case in 2017 about how, we used to have a debate about what is the most important forum for exchange of ideas. Now it is not debatable at all. It's clearly the internet and social media in particular. And I had the opportunity to interact with him at a conference earlier this year, and he said, having said that, and suggesting that the same strong free speech principles should apply precisely because of the importance. By the way, that was a case where the internet was being regulated by the government. So he was saying government has to protect the same high free speech standards there. He then said in this group of mostly law professors with whom he was having breakfast before the conference that he feels so, and it was not off the record, he feels so troubled about precisely that question, notwithstanding having made those grand pronouncements, that when he teaches a free speech seminar, that's his final exam. Easy to write the final exam. He just lists a series of major First Amendment doctrines, and then he asks his students, should this doctrine be changed in the internet context?
There you go. Yes, Robert.
And I was going to say, I don't think some of the problems that need to be addressed are limited to for example, like the virality of the internet, et cetera. I think there are other social issues that abound, and I don't mean to sound like a socialist because I think personally I'm more sort of libertarian leaning, but given the concentration of wealth in the United States today among certain people and what you're saying about, if there's harmful speech and it doesn't rise to a level that it should be forbidden by the First Amendment and the Constitution, that contrary speech is helpful, you need to deal with literacy issues, access to education, when there's such a great disparity in wealth that it's so concentrated in the handful of certain people, and you're in a society that's a democracy where you have a one-person, one-vote situation, you have a completely uninformed portion of society that can't make well-informed decisions because they're not well-informed. And so that's something that social media, to an extent, has the ability to correct, and I think that's why it's important that we get this right.
Evelyn, others? Okay. Yes.
I had a question. Sorry, they gave me the mic, so I'm going to use it.
Okay, and then in the front, yeah.
So with all this conversation, I was just wondering, I guess my general concern is why should I trust corporate governance? I mean, we have the idea that, that what's in the interest of the organization is going to be in the interest of the people because, capitalism will take over and then the people will ultimately stop using, for instance, Facebook if they don't want to use it. But we've seen that that's not true. People don't know the things that Facebook is doing, and they're sort of happily ignorant. So I don't trust corporate governance to make the right decision, and at least with the government, I can democratically elect those individuals to make these decisions. So my ultimate question is, why should I trust corporate governments to do the right thing when we know that their main end goal is to make profit?
Who would like to address that?
It's pretty for Zoe.
So what I would say is yes, yes, except on the last question, the very last comment. I think it goes back to what Kate is saying is that there are some cases where governments are now deciding for people who did not democratically elect them. So that's one issue. The second issue, in terms of why should you trust corporate governance, it's certainly not because you're sitting here and Zoe Darmay from Facebook is telling you to do it. I think the proof in the pudding will be whether these decisions are better, fairer, and more transparent over time. So I go back to what Nate Persley says. Nate's from Stanford Law. He said, remember, Zoe, that legitimacy was not born in the Supreme Court right when it started hearing cases. It took decades and decades for it to earn its legitimacy. And so I think that will be the same for the Oversight Board. I'm not asking anyone to automatically bestow a sense of legitimacy or credibility on the board in January or February when people first start convening and hearing cases. I think the legitimacy will be earned over time as the board grows its body of reason giving, which is really the key to the board's existence, is having conversations, really difficult conversations about speech out in the open instead of behind closed doors.
So I think we'll have one second. Did you want to ask a question? So we'll do, no, you can go first and then you'll go second. And that's what we'll.
It was just a response to.
Okay. Okay, so we'll go, I forget your name again?
Yeah, Hannah.
Hannah and then Kate, and I think that's what we'll have time for. So we'll have two. Kate, you're going to get the last word. Hannah, go ahead. Or the last question.
I was just curious, I think it was mentioned earlier that the type of content that you're going to be reviewing on appeal is posts and videos and things like that. And I was wondering if that includes, ironically, the defamation case that just came down, because that was a comment on someone's post, and I don't think that would be appealable. And also live videos, someone is doing a shooting and it's live. I mean, how are you going to react when you have a 90-day appeal time as opposed to something that's instantaneous and can be posted immediately?
So comments on post are considered content, so they could potentially be reported and appealed. On that specific case, that would probably be out of scope because it's been legally decided, and so cases that are within our legal questions are out of scope for the board. On the second part of that question, which is about Facebook Live, so if you're talking specifically about the Christchurch video, for example, I mean, Kate mentioned earlier that there are cases that are so urgent and time sensitive that there would be an expedited review by the board. So I could foresee something similar being very urgent and extraordinarily time sensitive that would come to the board in a quicker fashion. However, I should say that we will still be making immediate decisions. It's not like the next explosive, highly urgent video comes online tomorrow and then we give it to the board and wait 2 weeks. No, we will continue to make decisions because we have to.
Kate.
Okay. I was just going to kind of follow up on the economic question and kind of maybe to kind of close out things, because I think it's a question I get all the time. I know you get it, Zoe, but I'm sure Evelyn does as well. But I think that a lot of people want to know, there's a lot of confusion around how content moderation works in terms of the economics of the minutia of content moderation. So let's give actually this Christchurch shooting as an example. One of the things that a lot of people had asked me, because I wrote a piece about that what specifically happened behind the scenes at Facebook to get that video taken down once it was going viral. But a lot of people said, or say to me, that they think that the video stayed up for so long on purpose, and that Facebook didn't do anything to take it down because it was in their economic best interests, because it was generating ad content and impressions, and so why would they take down something that was and like, it's not this scale. So I know what I say in response to that, but I would be interested in kind of, Zoe, if you can shed some light on that and how that really makes sense. And then basically, I think talk a little bit about what, if not economic decisions based on one particular piece of content are driving the board, the kind of big picture of the economic relevant, of like how Facebook has to stay relevant to people in order to continue having a market at all.
So let me make this very clear. We do not have conversations about monetization and then make decisions about whether content like the Christchurch video should stay up or come down. That's completely false. I would also say I've heard this argument that we leave things up on the platform because we want to monetize it and we're doing it all for the clicks. That actually runs completely counter to what our advertisers want from us. Our advertisers, I get calls all the time about brand safety and how much they do not want their ad for toilet paper or laundry detergent or you name it, next to a graphic, violent video. They just do not. There is no monetary incentive for us to do that. And so the reason I get impassioned about this is because Facebook is also made up of people, and we are people who care deeply. And so it's almost troubling to think that people are out there saying that we're leaving out bad content because we want to make money off of it. It's absolutely not true.
So it's 3:31, and before we close, Franz from the Journal will have a final closing comment.
Thank you, Professor Green. I'm Franz Sostovsky. I'm the managing editor of the Journal. I would like to thank everybody for coming here today. Without all your participation, we couldn't make the event what it was, so thank you very much. The fact that you care so much about the topic is really heartwarming to us, and we're very, very happy to have you all here. I'd also like to thank Kelly Dry for sponsoring this event, and thank you also to all our volunteers who helped make everything happen. Without you guys, nothing could run as smoothly as it did, so thank you very much. Also, once again, I'd like to thank Sarah Fabian for putting together the symposium and coming up with this fabulous, amazing topic and bringing together such fantastic speakers. To that end, thank you to all the speakers and all our panelists for coming out. You really made this event fantastic, so thank you very much. I'd like to thank also our moderators, Professor Green, Professor Luzebnik, and Andrew Selbst, for participating and for sort of helping with all the discussions. It's been fantastic. I'd also like to thank Chanel Hawley, and she is the Associate Director of Conference Services, and also Fordham Media Services for their support in the event. And with that, I'd just like to direct you all to head over across the hall to a reception. Many of the speakers will be there if you'd like to continue discussing these topics and further discuss issues that have been covered today. So thank you very much, everybody.